Hi, welcome to John Redmann, Power of Attorney. I'm John Redmann, and with us for this special segment of the show is two attorneys who practice in the area of criminal law and who do expungements. We're going to go right into the topic. I have with us today attorney Gene Redmann, my brother, full disclosure, and attorney Matt McLaren, also a former prosecutor in the Orleans Parish District Attorney's Office. Gentlemen, thank you very much for being with us here today.
Thanks for having us.
Let's get right into it. Gene, let me start with you. Why don't you define what expungements are and how do they relate to arrests and convictions?
Expungements technically mean that you have your conviction expunged or erased from your record, or in cases of acquittal, or if the DA decides to drop your charges, you have your arrest expunged or erased from your public record.
Okay. So for instance, I think many viewers out there watching the show, watching the segment, they may have in the past gotten in trouble. Could have been something minor, could have been something more major. In some instances, they may qualify to have old arrests, old convictions, wiped clean from the slate effectively. Matt, why don't you tell us, you used to prosecute people in the DA's office in Orleans Parish. Some people they would plead guilty, or they would plead guilty to a lesser offense. Tell us, what are options? Why don't you answer the next question? What are the options for people who get these convictions, or maybe it's an arrest that never got a conviction? What can people do to clean that up?
Well, I mean, obviously it's a major tool of prosecutors. It's a negotiation tactic, if you will. We offer, or when I was a prosecutor, we would offer the option of an expungable offense, so to say. And basically what it was your ability to, take responsibility for something that may have happened and have the option of taking it off. So the option really comes down to, once you plead pursuant to the Code of Criminal Procedure Article either 894 for misdemeanors or 893 for felonies, to be able to come back later after you completed everything and effectively have it taken off of your record.
Well, let me stop you right there. When you plead guilty to an offense,
right,
maybe the offense that's on the table, or a lesser offense because of a plea arrangement.
Right.
Maybe the DA is not certain to get a conviction, but he's willing to go to a lesser offense under 893 for felonies and 894 for misdemeanors. You're telling them that after a certain amount of time has passed, if they behave, if they do all the terms of the what do you call it, probation and whatnot, they could come back to the court later on and say, look, I've done everything as I was requested. Now I want you to expunge or take it off of my record. Did I get you right on that?
Yeah, that's exactly how it kind of goes down. You come back to the court with your motion and your order done, and the judge reviews it. The district attorney has an opportunity to be heard about whether they want to agree to it or not. And then if everyone's in agreement that it should be expunged, the judge signs it, you pay the fees, and it's effectively taken off your record.
Gene, you've been practicing over 20 years, a lot of criminal defense. What happens if somebody is convicted, but there's not that 894 or 893 condition, that article of the Code of Criminal Procedure condition 893, 894?
Well, unfortunately, if you don't work out a plea agreement where you plea under the correct article, 893 for felonies, 894 for misdemeanors, you don't have the expungement available to you. So that's why it's important to talk to a knowledgeable attorney before you get to that stage, and make sure if why a plea may be favorable to you, rather than rolling the dice with a trial. And for most non-violent crimes, that expungement is available to you.
Okay. And I don't want to forget to say, if you are arrested and it leads to no conviction or no plea deal at all, maybe they decide they're not going to prosecute you, or you go to trial and you win, and faith smiles on you and your innocence is revealed at trial, no conviction whatsoever, no plea deal, there's an arrest record out there, you can get that expunged too, right?
That's correct. And as a matter of right, the state has to take that off your record because you are an innocent man. So
you still got to jump through the hoops. You still got to do the paperwork.
Hoops, but no fees. You won't have to pay the fee. The fee gets waived as a matter of right because you've either been acquitted or the district attorney has decided that your arrest, let's say, was not correct.
And let's be clear about fees. The state charges fees every time you go and request an expungement, the fees to the state in an arrest where there was no conviction or plea, those fees are waived. But if you have an expungement, you may be paying fees to an attorney who's got to go through a lot of hoops to get that expungement done, right?
You may contact an attorney and say, I've been acquitted, and that attorney may charge you a fee for him to go through the hoops while your state fees may still be waived. Okay. Or you may hire an attorney and say, I pled guilty pursuant to either 894 or 893, and I want this expunged, but those are state fees that are mandatory that cannot be waived.
Okay. Can people do this expungement steps on their own? Can they go to the courthouse and say, I had a 893 expungement a while back, I did everything that I was supposed to do, I'm pretty sure I'm eligible for expungement now? Can people just try and fill out forms themselves and not hire a lawyer and incur that
anybody
expense?
can represent themselves, but you know the old saying is a lawyer who represents himself has a fool for a client.
Right. It's very risky.
Right.
And just from your experience, Gene, why don't you answer this? When you're trying to do an expungement, is it just fill in the blanks, check off the checks, pay the fees, and turn it in, and you're done?
Mostly no. Certain courts, for example, New Orleans Traffic Court has a fairly simple expungement process that a lot of people could probably do. But most courts require that you set aside your conviction first, in the case of a conviction, for example. And they don't have forms for that. So
there's preconditions, things you got to get done in association with requesting an expungement.
Prior to the expungement, you have to have your conviction in cases of where you've pled or been where you've pled to have your conviction set aside. And my experience is that most people can't do it.
So you probably had people come back to you and say, I tried to do it, but I hit a brick wall. Turns out I did it all wrong, and they got to do it all over again. And then they pulled out a lot of their hair, and now they're coming to see you to get it right.
Many people do that. They try, and not to say no one can accomplish it. Plenty of civilians can do it, but it's relatively affordable. Most attorneys charge affordable fees, and it's a smoother process, and you're much more likely to get it accomplished.
All right, and we're starting to run short on time here. I'm sure people want to know, gee, if I got drunk in Bourbon Street one time when I was younger. And by the way, if you had a crime when you were a juvenile, not in adult court, but juvenile court, people don't have to worry about that, right?
I would say, yeah, you wouldn't really, no one's really going to find out about that because your juvenile records are sealed.
They're sealed automatically.
Per the state. Okay.
But what does it cost to get, just in the greater New Orleans area, Metairie, Jefferson, Orleans, St. Tammany, approximate cost to get an old conviction for a misdemeanor or a felony expunged? Just give a rough idea, because we're short on time. I want to get to the last question or two.
A regular misdemeanor will usually cost you, if you include the court fees, which run anywhere from $300 to $400, will cost you roughly between $1,000 and $1,200.
Okay. If it's more complicated, if it's a couple of convictions, if there's some red tape, the cost can go up, but you'll know that going in, and you get a free consultation with pretty much any lawyer if they just look in the yellow pages or go online and find a reputable lawyer.
I would say that, yeah, most lawyers that you contact will do a consultation, and most lawyers aren't even going to really make you probably come down to their office and sit down and go through this whole thing. They can probably do it over the phone with you.
Well, we're just really short on time, so let me just get to another question, and this was one of the questions that people wrote in and asked: what is a person's responsibility to disclose a conviction on, say, a job application or maybe a school application for college or graduate school?
Well, clearly you want to tell the truth on the application, so it really depends on the wording of the question. For example, if the application says, have you ever been convicted of a crime, and in fact you have been convicted of a crime, even though you've had it expunged, you were still convicted and you had the conviction set aside. And now,
the truthful answer is?
Truthful answer, yes.
Yes.
However, expunged.
My conviction has been set aside by the law, and it has the same effect as an acquittal now under the law, versus if the application says, do you have any convictions on your record? And if you've had a conviction set aside, you don't. So you can truthfully say, I don't.
Conviction on your record set aside. All right, well, gentlemen, we're very grateful to you both for joining us on John Redmann, Power of Attorney. We hope that everyone who sees this segment. If you're interested in more on the topic, we have Court of Appeal Judge Paul Bonin, formerly of the Traffic Court, on the segment this Tuesday. That's October 16th. You can watch that segment also on this website. Thank you very much for being here today, and we look forward to seeing you another time for more criminal defense attorney perspective. Thank you very much.
Thank you, John.